Yeah, thanks. So you are all currently on mute as attendees. And if you have any technical difficulties, just send a text message to the webinar. I think it's called the organizer. And just pose whatever question you have, and Mohammed will be able to hopefully answer that. In terms of our discussion periods during this webinar today, what we're going to do is you'll have to raise your hand. If you all look over to your control panel, you will see there is an image of a hand with an arrow pointing upwards. Just hit on that, and it will allow you to ask a question, and we can unmute you. Unfortunately, we can't keep everyone unmuted throughout the webinar because it would really degrade the sound quality. And for those who are presenters, again, I ask that you please just keep yourselves on mute, again, to improve sound quality. Okay, so I'd like to thank, right there, okay, I think someone is on there. Okay, great. So I'd like to, just one second, I'm muted. I'd like to thank everyone for being here today. In particular, we have Debbie Avent, who is going to be moderating today. And I will introduce Debbie shortly, and she will in turn introduce our panelists. We've got 6 panelists here today, and we're really looking forward to hearing from them. They come from various sectors, private and government. And speaking of government, Chris Mayer today will be moderating our discussion, which will be based on a scenario that you all should have received. If you signed up as of yesterday afternoon, I've sent you that scenario as well as a discussion paper, which frames some key thoughts and questions for that discussion around Alta and Sierra. And I think someone is actually unmuted amongst the presenters. If you guys could go ahead and I'll make sure that you're muted, that would be great. So, as I said, today's the second in a series of 6 webinars, and we're exploring requirements and methods for delivering essential training relating to the operations of private military and security companies. And I think last week Chris did a really great job of kind of summarizing the purpose of these webinars very clearly. He said that the purpose is to identify the training that is necessary for the responsible provision of security services, the intended audiences for the training, the methods of delivery, and the means to assess the effectiveness of that training to achieve the intended goals. And I think that's a really nice way of summarizing what we're trying to do here today. Last week, Jamie Williamson from the ICRC and Chris talked about some of the training requirements that are emerging from the international and national standards that are applicable to the industry. And Chris helped frame the problem by highlighting some of the key questions that need to be addressed in order to create effective training. Who needs to be trained, on what, how do we best train in terms of pedagogy and methods of delivery, when do we train, and how do we ensure quality. So today is really focused on who needs to be trained. And we'll frame that question broadly, as we said before, not only in terms of actual security providers, but others as well that interact with the industry, other stakeholders. So as I mentioned last week, we really hope that all of you will work with us to generate ideas and propose practical solutions for these questions. To that end, as I said last week, we are creating an email burst that will allow all of you who choose to participate in that conversation moving forward and between webinars. It's really meant as a venue for you to share thoughts, post interesting information, have discussions, that sort of thing, because unfortunately, 2 hours is not much time, even though we're doing this 6 times, to really get at these questions that we're posing. So, many of you have tremendous expertise in this area. You've been involved in developing standards and contracting requirements. You're maybe already offering trainings. So we really hope that you'll take the chance to share that expertise with everyone else so we can learn collectively. The bios for today's presenters and our moderator, the full bios are actually on our website, www.ihrid.org. So we don't unfortunately have time to read through them. The folks who are with us today are pretty impressive and have long bios. So I'll let Debbie introduce them in more detail in a second, but I'd actually like to introduce Debbie first. Debbie Avent is, Dr. Deborah Avent is the I'm going to mispronounce this, I apologize, C. Chio Kang Chair for International Security and Diplomacy and the Director of the C Center for International Security and Diplomacy at the Joseph Corvo School of International Studies at the University of Denver. Under her leadership, the C Center has launched a wonderful website called the Private Security Monitor. And if you haven't had a chance to look at it, I really encourage you to do so because it's truly, I think, a one-stop shop for everything related to PMSCs. And probably all of you probably know who Debbie is. She probably doesn't even need introduction. But she obviously has done tremendous research and has very voluminous publications on a number of issues: civil-military relations, military change, and the politics of controlling violence. You probably all know her best for one of the first works really examining this industry in depth, and that is the book, The Market for Force, The Consequences of Privatizing Security. So if you haven't had a chance to read that, I really encourage you to do so. So with that, I'm going to hand it over to Debbie to go ahead and introduce our speakers. Debbie, can you take it from here? Okay, let's see. Debbie, we can't hear you. I'm not sure why. You may want to check to make sure that your microphone is on your computer or your headset. Okay, if you'll bear with us for one moment while we figure out here what's happening. Yeah, we can't hear anything, Debbie. Okay. All right. Sorry, folks, for the slight minor glitch here. Debbie, I will, let me see here if you have sent an email. She says microphone is on, I'm unmuted. Do you want to take it? So for some reason it doesn't seem to be working. Okay, so apologies for that. We'll try to figure out what may be happening. Debbie, maybe if you could try to fiddle on your end. We're not seeing any indication as to why we can't hear you. So I'm just going to jump in and go ahead and introduce our speakers. And I think what I'll do is just introduce them individually before they speak, rather than trying to go through all 6 of their bios right now. And so I'm going to start with Chuck Tucker. And Chuck Tucker is the Executive Director and co-founder of the Rural Engagement Institute. He previously served as Executive Director of the International Human Rights Law Institute in Chicago. He is a Major General retired, and General Tucker's mission is to develop and promote the fundamental rights of peoples around the world through education, research, documentation, capacity building, and advocacy. And to accomplish this, he and the WEI Institute engage in contemporary human rights and rule of law research, training, and advocacy, as well as post-conflict justice capacity building programs and large-scale human rights documentation projects throughout the world. Chuck prepares international students, professionals, and scholars for institutional capacity building, rule of law, and human rights careers by administering international institutional development projects, fellowship programs, special courses, internships, and research opportunities in Chicago and abroad. So I'm going to leave it at that for now. There's much more to learn about Chuck, and I encourage you to go to our website and read his full bio. And with that, Chuck, I'm going to hand it over to you.
Thanks, Rebecca. It's good to be with you, and welcome from sunny Chicago. We should have a conference here someday because the weather is always as perfect as it is here today. Let me start by saying that you know, I'm a recovering, as my bio says, I'm a recovering Major General. I'm a recovering lawyer, and the question is, to what extent over the last 30 or 35 years has this industry morphed? From where I sit, from a legal standpoint, we've been looking at the issues of contractors in the battlefield and contractors in complex environments for at least 35 years in my professional career. Originally, excuse me, I'm getting over a cold. Originally, the questions that were coming to us, those of us who represented governments, was to what extent contractors were going to perform an inherently governmental function. There was a lot of pushback within the military and elsewhere to bring contractors in, to get them into what was euphemistically called the kill chain, and to what extent that would be permissible under international law. Simultaneously, during the Cold War, we had a number of issues of what were then referred to as mercenaries fighting in such places as Africa, and that set up a separate body of law. But the body of law that I was primarily dealing with were to what extent the military, if you will, could order contractors to stay in the battlefield in case there was a conflict, how we would, the command and control issues that went along with that, the liability issues that went along with that, and so forth. But until about 1995, the largest personal services contract that the U.S. Air Force had was the Turkish base maintenance contract. and that was just as it says. This was in essentially a time of peace, contractors that were performing maintenance functions at the base. We weren't primarily focused on private security contractors per se, and I didn't see those kinds of issues coming up until Bosnia, around 1995, give or take. So I think, again, you've got to go back and look from a legal standpoint and say, you know, while contractors have been in complex environments working with governments for, well, at least as long as the United States Republic has been around, starting with settlers back in, you know, during the Western campaigns. If you want an interesting view on the use of contractors from a cinematic standpoint, it'd be worthwhile to go and see something like The Fighting Seabees, an old John Wayne movie where we had contractors originally building airfields during a time of war, and some of the issues that came up. That whole movie is about the legal issues and the complexities of dealing with contractors in a war zone. But again, from my standpoint, primarily what we were looking at were contractors who were not in the kill chain performing maintenance functions. They were doing electronic work and so forth. So this issue of contractors engaged, contractors carrying guns, working for, let's say, legitimate governments, didn't really come up until around 95. And what I saw was you had contractors who were primarily in a training function in the Balkans, working with certain factions. And then in 95, when the, if you will, when the Dayton Accords came up, they moved into more of a training function, but then began to get more into a security function. And I saw that kind of morph between 95 and 99 when we went into Kosovo, where increasingly I was seeing contractors carrying weapons in a complex environment that wasn't war but wasn't quite peace, not only protecting governmental entities, but then beginning to protect NGOs, corporations, and so forth. By the time 2003 came around, I began to see contractors in huge numbers in Afghanistan and later in Iraq. So I would say, at least until that time, the primary issues from a legal standpoint were traditional international law issues, which fit comparatively well. I don't have time to give a lecture on international law, but obviously it's state-centered, it's Westphalian, where contractors, non-state actors, if you will, were not seen to have the requisite gravitas, weren't seen to have the status to engage in treaties and so forth, didn't have the legal status to do so. And so it was governments that were being held accountable, or not. The issue increasingly, though, is what do you have when you have non-state entities, non-state actors who are hiring non-state actors to engage in a term that a lot of people don't like, but I'll use it anyway, which is kinetic engagements. From my own standpoint, my own NGO is performing training functions in the Sudan, South Sudan, Afghanistan, still in Iraq. As an NGO receiving funding both from public and private funds, we have to hire private security contractors to do our work. Recently returned from Somalia, where we're working with the private security contractors simply so that we can perform our work and stay alive. So I have a non-state actor working with a non-state actor, and I would say that I won't call it the dirty secret, but the secret is that by numbers, the largest numbers of private security contractors being hired as a group, as a totality, are not by governments or by militaries or by foreign services, but they're being hired by NGOs and corporations. In other words, by volume, the largest question we have is how do you have one non-state actor who has, let's say, limited status under traditional international law? How do you deal with that when it's itself hiring another non-state actor which has limited status under international law? Now, when we talk about international law, primarily, again, without going through all this, what we're primarily talking about is international criminal law, international humanitarian law, and so forth. And without getting into the details, one could say that it's not a good fit. international humanitarian law, LOAC, obviously international criminal law has limited let's say, things to say in this environment. So my concern as I sit here today, both as a user of contractors, private security contractors, as an NGO, as one who does work for governments and receives funding from governments, so the question comes up, to what extent am I a governmental actor in an agency principle? The question also is one's of liability for me. As the head of an NGO, with a board of directors of an NGO, who receives public and private funds, who has contractors in complex environments, one question I have is, what liability do I have when I hire a PSC or I hire a company that engages in these kinds of activities? What liability might I have? Now, when I was with the government, we used to say that there are two questions lawyers typically would be asked. Well, there was really one question, which was, can we? Can we do this? Can we do that? What does the law say? Make your case, counsel. I used to push back and say there should be a second question, which is, should we? Not only can we do this, but what should we do? And I think that that's the big issue for groups like ours. What should we be doing in the battle space? I can certainly come back to my board of directors and to my funders and say, well, look, international criminal law, international humanitarian law may not apply to us under a variety of circumstances, but if this goes badly for us, we have reputational risks, and we're going to have to deal with those. But even that, even going beyond that, I could say that the law seems to be morphing for us. In other words, when I was doing, as a private attorney, I used to be asked about, precedent, and I say, precedent is history. The question is where, particularly in the common law environment, you can move the law forward. We're seeing the law being moved forward. When I was in the military, the term was lawfare. There was great concern about the law being used as a weapon against the military. Now increasingly we see the law, if you will, international and national law, being used against corporations and increasingly against NGOs. The Alien Tort Claims Act cases that have recently come to the U.S. Supreme Court are one example of that. And while the Supreme Court recently pushed back a bit on the Alien Tort Claims case, the Nigerian case, it didn't do so on the basis of what was put before it, which was to what extent are corporations liable for their acts. Instead, the Supreme Court pushed back on jurisdiction and talked about whether the U.S. had jurisdiction over a corporation for acts in another country where that country had an existing legal system and could be prosecuted theoretically under that legal system and had comparatively limited contact within the United States for the acts involved, whether it was going to be held liable, and the court, in a split decision with concurring opinions, pushed back and said, no, there's a lack of jurisdiction. I would, just on that particular case, I don't think, the issue is certainly not over. For example, the Chiquita banana case, the Colombian case is still proceeding in the 11th Circuit. In that case, you had issues of whether a subsidiary of Chiquita Banana was hiring mercenaries or paying local militias for protection. There was a criminal case brought against the corporate entity, and they settled out of court for a reported $25 million fine. The civil case is still proceeding under the Alien Tort Claims Act and traditional acts and traditional causes of action, as well as in Colombia. And I think that case should give all of us some pause, and I'll more or less end this portion of it. The civil and criminal aspects of a board of directors of an NGO or a corporation, both non-state actors, will continue to be a matter of litigation within the various federal courts in federal systems. It will be considered litigation in the European Court of Human Rights. These issues are going to continue to be the fore. The Chiquita Banana case gives you some pause to think, look, what happens? I'm sitting in Chicago. I have a chief of party, let's say, in the Sudan, who's hiring private security contractors may be talking to me about it, maybe not. Maybe we don't want our funders to know about it because that's not the kind of thing they like to hear about. Those security contractors have limited oversight from the headquarters, may have some limited oversight from the field because the field is not trained or experienced in dealing with contractors. My contractors are then dealing with military forces, maybe under a UN force, maybe under a US or NATO force or a coalition force, and they're carrying weapons. Under those circumstances, I think from a training standpoint, we all have to wonder, what should my board of directors be trained on? What should my chief of party be trained about? What should my training officials be trained about? Should we be exercising together with our private security contractors so we know what chains of command will be, what the rules of use of force will be? Should we be talking to our customers about this? And certainly, how do we interact with other forces? So I'll just sort of end on the issue that from my standpoint, the biggest question I have as I sit here today is not whether this is inherently governmental. It is not whether how do I hold governments responsible for their actions, but increasingly we have to wonder in our own shop what our corporations and our own NGOs, what responsibility we have and how we're going to have to deal with these issues in the future. Thank you.
Thank you so much, Chuck. That was very useful. Certainly this industry, due to its complexity, raises a number of legal issues, and I think you pointed us to some of the very key ones. I'm going to try to see if Debbie can now actually pick up and speak. Debbie, can you try saying a few words? Okay. Okay. Debbie, I'm still not sure what's going on. we're going to continue to try to work that out. So let me just go ahead and introduce our next speaker, who is Richard Phillips. And Richard Phillips is the Chief Operating Officer of Strategy for Consulants and Director of Edinburgh International. He is a graduate of St. Andrews University, and he was commissioned into the British Army in 1991, becoming a captain and pilot in the Army Air Corps. After leaving the service, Richard spent 6 years learning and providing sales management with 2 London commercial IT service companies, but it was in 2004 that he actually joined at that point the fledgling Edinburgh International. And with the sales and proposals team, he quickly helped grow that company. I think particularly interesting is his role included Edinburgh International's governance, risk, and compliance function, and he ran the Government Risk and Compliance Enhancement Program for 2 years. And in that capacity, he was doing a number of things which I think is very relevant for our conversation today. He specifically analyzed the compliance and training requirements of international humanitarian and human rights law, the International Code of Conduct, and PMSC, the Management System Standard for private security providers, as well as other legal and voluntary requirements. This program then designed and implemented the delivery systems and real-time audit mechanism for these requirements. He's also been actively involved in the development of the International Code of Conduct and the establishment of the Code of Conduct Association. So, Richard, it looks like you already have the screen. I'm just going to hand it to you, and Chuck and others, can you make sure you're on mute? I think we can still hear you. Thanks so much.
Thank you very much indeed, and good morning, good afternoon, wherever you are, from a very damp Suffolk, I'm afraid to say. Right, I'm going to be focusing on who needs to be trained within the PSC. You'll note I don't use the M word, as we do nothing military at all. Let's go straight into that, he said. There we go. With apologies for those who already know this or who work within the industry, I need to just explain very briefly, for those that don't, how PSCs run, or at least some things that are very useful to know about them. Now, what we have in front of us is a very simplistic representation. To put this into context, we see 5 projects there. We currently run 47. Now, private security companies all have different operating models, so this isn't by any means standard, but it's typical. And the thing really that I want to highlight is that what we are doing is providing trained and experienced people, largely, and that we are project-based. Now, obviously, we don't just provide people, we do so within a framework, and that's really what we're going to be looking into in a little more detail. There we go. Okay, so what we have to sort of understand a little bit about is that we have this sort of permanent or overhead function in the headquarter element, but we have considerably outnumbering those people contracted staff. So the headquarters and the relatively likely manned regional or country headquarters typically have a lot of contracted people working for them, because the projects by their very nature will run for a month, 2 months, a year, 2 years, but they have a finite life to them. So we have contracted individuals within that. And this has a bearing on how we assess who needs to be trained, which we of course will come back to. So another thing I just wanted to point out is that each and every project is slightly different, and we will all have what we call different drivers, and the requirements that flow from those. So what do we mean by a driver? And this is very much our terminology. I wouldn't suggest that this is a sector terminology. It's just what we called it for our own, so we can understand what we're talking about. The International Code of Conduct is a driver for us. PSC 1, UN Global Compact, Voluntary Principles, the UN Guiding Principles, Federal Acquisition Regulations. We consider these all to be unique drivers. And some of these drivers are universal to all and sundry within our organisation, to everything we do. For example, the International Code of Conduct, PSC 1, the Guiding Principles, Human Rights Law. They are universal to all of us and to everything that we do. However, some are very much more project or client specific, e.g. Federal Acquisition Regulations, the Voluntary Principles, or indeed stated ISO requirements from clients. So just really sort of illustrating the complexity of the compliance environments in which we live in. I'll come back to that point in due course. Now it's fair to say also that the specific requirements within these drivers may or may not be universally applicable, because International Code of Conduct doesn't give you one instruction, it gives you very many. So what we had to do was map these requirements. First and foremost, we had to identify them. And what we did was we looked at, and again my term or our term, drivers, we looked at those. I suppose you could categorize these as saying those about which we had no choice, i.e. the ones that were given to us via international law. I know for all the lawyers in the room, they'll say there's no such thing as international law, which brings us on to national law. A good example being human rights law, inherited from international law, labour law, regulation, tax law, those sorts of national laws for where we're operating. But also national law for our home countries. Our organisation gets to inherit both British and American legal obligations, which is fun. And then, of course, we have those that we have no choice about because they're contractual, be that Federal Acquisition Regulations or in Afghanistan, for example, NATO or ISAF or CENTCOM fragos, those sorts of things that that exist, we need to be aware of. So we're identifying all of these. At the same time, we're also identifying, and we could call those ones, I suppose, typical compliance. Or legal compliance. However, we also included things that weren't typically legal per se. They were self-imposed or voluntary. And the first of those were indeed voluntary, including those that we signed up to, like the International Code of Conduct, UN Global Compact, UN Guiding Principles. These are things we don't have to do, but we choose to do, though in many instances we are encouraged to do so, or indeed insisted, our clients insist that we do them. We also have the ones that we self-impose for our own quality. ISOs fall into this category, and our operational minimum standards. And just to make the point again that we call these all compliance drivers, though clearly they go beyond the standard legal definition of compliance. Okay, we then look at each and every single driver, we read them in depth, and we take out and extract every single requirement, and clearly there are lots and lots and lots of these in each of these. And every single one of those drivers, and we have over 100 of them, will have a number of requirements. Indeed, these compliance requirements is a very long list for us. We've got over 1,000 of them, but it's worth noting that there's clearly a vast amount of overlap between the different drivers, so we have to go through a deduplication process, though we do maintain the link back to the driver to for audit purposes. So once we've analysed and captured all of the requirements, what we then went about doing was ensuring that there was, we grouped them in an appropriate fashion, and that went across drivers. It wasn't, we didn't do it in a linear fashion from driver through to result. But we ensured that all of the requirements were met via a compliance system that sort of was based around policy, procedure, training, and or other mechanisms. And there's an example there which is highly representative. It's very simplistic. It's just a very small slice of our Code of Business Ethics and Conduct, illustrating that underneath that there's an ethics hotline procedure, and underneath that there are posters and lesson plans, lessons, assessments, etc. All in all, what this gave us was a compliance matrix. At the very top, I mean, clearly you can't see this. I'm afraid it has to be printed 6 feet wide to be actually be able to read it. But at the top we have the drivers, and below those we have our, so in the dark blue are drivers, the light blue are our policies, or directives in some instances, and they lead down to the yellow procedures, and below those the grey tools, or things like risk assessments, the various sort of flow down from procedures. And then in green at the bottom we have all the lessons. Now in fairness, actually there are courses. Each of those could be 1 lesson or as many as 27 in some instances. We give, you know, in terms of what our compliance matrix actually means in real terms, just shy of 700 documents. Okay, so concurrently, whilst we were mapping the staff, we went through a functional analysis of our own organisation. It's all very well and good knowing what you're supposed to do. What we really want to get to is who needs to know what we've got to do. And what do we mean by functional analysis? Well, this was both what functions do we need to resource in order to execute our business, and how we resource to fulfill the compliance requirements, i.e. who's doing the actual human rights training as a dedicated function, and who within the org chart needs to do this training. And of course, that in this instance will be defined by our Code of Business Ethics and Conduct. So that enabled us to pull together an org chart. Again, this is representative, not real. It's a little bit larger than that. But ultimately, the policy in this instance, the Code of Business Ethics, and its supporting procedures also inform what training needs to be done. So we end up with a training matrix that defines what all permanent staff must do, and it gives direction for project staff, who I mentioned at the outset, will start up when we win a piece of work. And the way we confirm exactly what the training requirements are is to confirm this in what we call our project management plan, which of course is instructed by the training matrix. What does this mean in real world? Again, unbelievably simplistic representation, but this illustrates how different personnel have different training requirements. And you know, if we were to look at a sales manager, you know, why would he need to know about the Alta Sierra laws? Well, because he's selling a solution. If he's misrepresenting what we can do, then that is relatively dangerous. Does the headquarters finance clerk need to know about Alta Sierra laws? Potentially, but probably not. They certainly have no interest in the rules for the use of force. Whereas all operational staff, and they're the ones in blue, and typically, by the way, they will also be contracted, you know, there we could see rules for the use of force working you know, all the way through. So that sort of gives you some indication of how we do it. Clearly the reality is very much more complex than that. Lastly from us, and obviously that just explains what International Code of Conduct requires. As I mentioned, there are dozens and dozens of drivers. We don't tend to think about drivers once we've got past our analysis. We purely get down to what do you individually need to do. And we have a mechanism for implementing that, for measuring that it's being done and analysing it in real time, which thankfully is outside the scope of this particular question, which is who needs to be trained, and I'm not going to tell people about that because I've got competitors listening. Lastly, a plea from us to clients, and that is that when we start up a project, there is an enormous amount of training to do. So if you ask us to do so in 3 days, we are going to be behind the drag curve from the outset. We are consistently pushed by clients into meeting unrealistic deadlines. And if we all wish to have the proper training in place, then we please must have more time to set up correctly. I will finish on that note, but thank you very much indeed.
Thank you, Richard. I think your task sounds very daunting. That compliance matrix was incredibly complex, but obviously you're really tackling this head on. So thank you for sharing that information. I'm going to try one more time to see if we can hear Debbie. Debbie, can you say something?
I can. Can you hear me?
Yay, yes. Success.
Yay.
Welcome,
Thanks.
Debbie. Again,
Yeah.
everybody, Debbie's
Thanks, everybody.
Debbie's with the C Center, and I want to thank Debbie. I forgot to say this at the outset. Debbie is one of our co-sponsors along with INSA. Trevor Hughes will be talking later on INSA's board, and the International Institute of Humanitarian Law. So I forgot to say that, Debbie. Sorry, and thanks for being here, and thanks for being a co-sponsor.
Great. Thanks for everybody coming, and for the first two presentations, which I thought were really interesting. It sort of gives us a sense of the breadth of what we're talking about here. And I'm looking forward to hearing our next speaker, who is Timothy French. Timothy is a U.S. citizen, but an advisor with the Unit for Relations with Armed and Security Forces with the ICRC in Geneva. And he has, before he worked in Geneva, he was Deputy Legal Advisor at the Washington Regional Delegation to the U.S. and Canada, where he was responsible for legal support to the ICRC. He also has a background in the Navy and went to Georgetown. So we're looking forward to hearing you, Timothy.
Hello, can I be heard, everyone? Hello.
Yep, Tim, we can hear you.
Okay, great, thanks. Well, good morning, everyone, and thanks for inviting me to participate in this webinar. It's not often that I get to share the stage with such distinguished practitioners and scholars, so I'm very happy to be here. Just in case some of our listeners don't know or are not aware, I work for the International Committee of the Red Cross at our headquarters in Geneva in Switzerland. I highlight that I work for the ICRC because I generally find that there is some confusion about the ICRC and the role that it plays in the international movement of the Red Cross and Red Crescent. And I'd like to just take a few seconds to clarify a few important points about where the ICRC fits in the scheme. And maybe that will explain why I was invited to this webinar. The ICRC, where I work, is actually the oldest body in what we call the Red Cross, Red Crescent movement. And we think of ourselves and identify ourselves as a very impartial, neutral, and independent organization. And we have a humanitarian mission to protect the lives and dignity of the victims of armed conflict and provide them with assistance. So it's safe to say that our mandate and our relevance is strongest in situations of armed conflict as a legal matter, armed conflict of an international or a non-international character. The International Federation of the Red Cross Red Crescent Societies is a body that was created in 1991 to coordinate the national societies that exist around the world. And there are 189 national Red Cross and Red Crescent societies in the world, like the American Red Cross, the Brit Red Cross, the Syrian Arab Red Crescent, to name a couple. National societies are set up by an act of legislation of their national governments. And they provide a range of services, including disaster relief, health, and social programs, among other things. Together with the ICRC, the International Federation, and national societies, we make up this entity called the International Red Cross Red Crescent movement. So I hope that clarifies things a bit, because those of you who may think, and certainly I thought when I first started my career, that the ICRC was the international arm of the American Red Cross, or part of the United Nations. It's not. We're pretty unique, and we operate very independently and always in a neutral manner so that we can be accepted by all parties in an armed conflict. Sometimes that commitment to impartiality and neutrality prevents us from taking public stances on specific issues, unless they push us in one way or another or toward a political manner. And in that way, we lose contact with one of the parties to a conflict. But we're committed to that mode of operating. And as our mandate primarily stems from the responsibilities tasked to the International Committee of the Red Cross and their delegates in the Geneva Conventions, we're commonly referred to as the guardians of international humanitarian law, or IHL. And when I was in law school, I thought of IHL as the laws of war. When I was in the military, it was the laws of armed conflict. They all refer to the same body of law. Now, regarding the broad issue of private military security companies, or private security companies as is the common parlance now, the ICRC has taken, or has a rather conservative position. But perhaps that's good, as the rest of our panelists today may look at things in a different light. Most, if not all, of my comments today stem from our position relative to the Montreux document, something that my colleague Jamie Williamson referred to in his presentation last week, and I'm sure that all the panelists today here are familiar with. The Montreux document clarifies and reaffirms international law applicable to PMSCs. Because of our mandate, as I described, the ICRC has a lot of relevant authoritative things to say if we can qualify the context in which the PMSC is operating as an armed conflict, outside of an armed conflict, but in a situation of internal disturbances or tensions or sporadic acts of violence. IHL will not apply as a legal matter, and thus PMSCs will be operating under the legal framework of international human rights law and domestic law. For the sake of the discussion today, I'm going to frame our remarks in the idea that we have a pre-existing armed conflict. Then to address the larger question of who should be trained, or to touch upon it, we have to touch upon a few other sort of sub-questions as well. I think we can all agree on what a PMSC is. We don't have to go through that dialogue, but I think we should probably start with what would be a PMSC status under IHL, and then we can think about who needs to know that. The status of personnel of the personnel of PMSCs in an armed conflict is really determined on a case-by-case basis, in particular according to the nature and circumstances of the functions in which they're involved. With that being said, unless they're incorporated into the armed forces of a nation state or have combat functions for an organizer or group belonging to a party to the conflict, the staff of PMSCs are simply civilians. And as such, all of the provisions or protections associated with being a civilian in an armed conflict apply. Suffice it to say that as civilians, PMSCs may not be targeted, and they're protected against attack unless and for such a time as they take a direct part in hostilities. If they are operating in situations of armed conflict, staff of PMSCs must respect IHL, and they may be held criminally responsible for any violations that they may commit. This holds true whether they're hired by states, international organizations, or by private companies. So the question relevant to this panel is, who needs to know this? Well, we think we can certainly start by saying everyone in the PSC management and staff should know it. If the function that I'm performing may result in my being a legitimate target of IHL, then I should probably know that. But I've been asked to focus on state actors, so we'll take the discussion then. And it's actually a quite natural fit for the ICRC to discuss about state actors because of something that Chuck mentioned earlier, or he mentioned earlier, which is that there's just been there is a proliferation of PMSCs in the world, and they're in their use. And as such, I think the ICRC, in its interpretation and its collective sort of approach to PMSCs, realized that it's probably better to approach oversight and control, if you will, over companies through their obligations to the state. So in that sense, Montreux document really imposes, or I shouldn't say it imposes, the Montreux document describes the responsibilities of the state vis-a-vis private security companies. And following Jamie's framework from last week's discussion, we would distinguish between the responsibilities of we've classified 3 types of states in this manner. Contracting states, or states that hire PMSCs, territorial states, or states on whose territory they operate, and home states, countries in which PMSCs are based. Because the 3 types of states have slightly varying levels of influence on how PMSCs operate, who should be trained within the government of each state correspondingly also differs. So starting with the contracting state. A little bit of the law. States cannot absolve themselves of their general obligation under Common Article 1 of the Geneva Conventions to ensure respect of IHL by contracting PMSCs. This general obligation is important because it requires states not only to refrain from committing violations of the law themselves, but to also take measures in their power, all measures in their power, to ensure that PMSCs respect the law. This aspect is universal and applies to all states. Should the staff of PMSCs commit violations, the state that has hired them may be responsible if their violations can be attributed to it as a matter of international law, especially if the PMSC acts under instructions or control of the state authorities. But contracting states are particularly well placed to ensure respect for IHL in this manner because it's relatively easy for states when selecting companies and entering into contracts with them to influence how they operate in the field. Thus, it makes sense that those within the government that have the authority to enter into contracts with PMSCs or are responsible for reviewing those contracts be duly trained and IHL applicable to PMSCs. Anyone involved in the selection process ought to be trained. Finally, contracting states also play an important role in ensuring the accountability of PMSCs if and when they do violate IHL by monitoring compliance through clauses or establishing criminal jurisdiction over crimes extraterritorially. So we can extend that to someone in the equivalent of the Ministry of Justice or state attorney generals when it comes to training. Shifting to territorial states, states on whose territory PMSCs operate, they're also in a strong position to influence behavior of companies that operate on their lands based on territorial sovereignty. It is true, though, that, and we see this often, that in an armed conflict scenario, this capacity might be limited or degraded if the state doesn't have sufficient control of its territory. Nevertheless, similarly, the Ministry of Justice or specialized prosecutors should be trained. One can envision a licensing scheme that companies may be required to get for specific laws on the use of force, possession of weapons, identification cards for PMSCs. Government officials tasked with these functions can be targeted for training. Home states have similar abilities to those of territorial states. Again, an authorization scheme to export PMSC services abroad is feasible and is sometimes done should conditions be met by the PMSC. Licenses and authorizations can be followed up by an accountability mechanism so that those in the government that the home state tasked with or holding the authority to sign these licenses are best places to be trained. Just want to touch upon, because I don't think anyone else in the panel is specifically assigned to speak about armed forces responsibility. I think that when it comes to armed forces, we have to go back to the concept of if they have PMSCs who are contracted to work for the armed force, then we may rub against the concept of direct participation in hostilities. Certainly when earlier in the decade, when I was deployed to Iraq, there were just 5 private defense contractors for every uniformed service member in context, if not a greater proportion. Not all of them were doing things that managed to or amounted to direct participation in hostilities as a legal matter, but it's important that that operational planners in the military know that if they use PMSCs in such a manner that it is DPHing, that the PMSC would lose their protection from attack. They would still be civilians, but they would lose their protection from attack during such participation. And if captured, they could be tried under domestic law for merely participating in hostilities, even if they didn't commit any violations of IHL. Finally, I just want to mention the human rights perspective, because I've talked basically exclusively about the context of armed conflict. And that's where the ICRC has something to say. We're not a human rights organization, but there are many contexts, and probably more contexts, in which PMSCs operate in a framework outside of of IHL. And Maltra touches on it a little bit. You probably won't find the ICRC holding anyone's feet to the fire on it, but PMSCs and their personnel are not necessarily bound to respect IHL, because, IHRL, human rights law, since human rights law is binding on states. But the states are required, if they've, in certain cases, to protect individuals against misconduct by PMSCs that would have an impact on their human rights. In other words, states have an obligation to take measures to prevent misconduct by PMSCs and to assist persons harmed by such misconduct. And to that end, you probably will find that many of the levers of influence that I described in the contracting state, territorial state, and on the home state would also be applicable for ensuring that, or would be relevant to be trained on international human rights law that PMSCs are bound, or should be aware of or bound by. So I just wanted to stop there. I realized that I couldn't get too far into the weeds. That's sort of the nature of our organization, to stay at a fairly high level when it comes to the discussion of PMSCs. But I just wanted to thank again for the opportunity to speak, and I look forward to the rich discussion later.
Great. Thank you very much. The breadth continues to expand, and I think we'll expand further with our next speaker, who is Trevor Hughes. Trevor Hughes is the Director of Risk Management and Global Security for International Relief and Development, or IRD. He has worked as a global security strategist and has 18 years of experience in security and risk management. Mr. Hughes served for 10 years in the U.S. Department of Defense and State, and has worked in international and corporate security across 45 countries. So, Trevor, we look forward to hearing what you have to say.
Thank you. I'll try to speed my way through here, and due to the time, but a couple quick comments. Basically, I'm going to be breaking down the differences in the wider humanitarian development community. A little bit more detailed than the others, perhaps, just because it is such a complex, wide community involving both strictly humanitarian, kind of double-edged development, as well as for-profit development firms these days. I'm going to oversimplify a lot of things, and in general my comments are going to be focused on international humanitarian development organizations or companies who are actually implementing in the field. So we'll just jump right in here. NGOs are extraordinarily unique. No two have the exact same objectives, mission, operating procedures, or capacities. International NGOs number in the thousands and vary widely in the performance, professionalism, their sense of responsibility, and attention to standards in accordance with the Humanitarian Code of Conduct. European NGOs and American NGOs can differ greatly in terms of priority, structure, culture, mandate, etc. The differences between them are most apparent when observing how an NGO perceives their own identity. Many NGOs in the UK are looked at as charities, which affects who and how they hire staff, and certainly affects the compensation and benefit structure of that particular organization and the people that are implemented in the field. In the United States, NGOs vary widely in every way, but when looking at the NGOs which implement relief and development programs globally, many are considered professional humanitarian or development organizations or service providers. The perception of being professional service organizations affects who and how they hire, as well as compensation and benefit structure, creating a distinctly different culture than the UK NGO charity model. Many development NGOs in the States have grown into what could be considered, again, a generalization here, as a category of their own. Well, in the past, traditionally, development has meant longer-term projects in mostly post-conflict environments. Numerous changes in foreign policy have affected the development priorities of the U.S. government donor agencies. Development typically still means longer-term projects with larger budgets when compared to humanitarian operations. However, when the development community embraced the concept of stabilization operations in the last decade or so, development work started to occur much more frequently during the conflict, and in some cases simultaneously with combat operations. U.S.-based development NGOs, in most cases, have multiple portfolios. In their humanitarian portfolio, many still try to take a principle-based approach, dealing with traditionally smaller budgets and applying an acceptance strategy for their safety and security requirements. While the same organization in their development portfolio may be conducting high-risk stabilization programs with much larger budgets in areas utilizing a mix of deterrence and protection as their security strategy to deliver these services. Some American-based development NGOs can look like both a contractor and a humanitarian agency, depending on which of their programs you observe. When referring to the humanitarian development community, we've got to recognize that while NGOs dominate the first responder role in humanitarian emergencies and many of the relief activities, the development community is much more diverse and includes a number of for-profit development companies. Development NGOs and for-profit development firms compete for much of the same funds, as well as collaborate in the form of prime and subcontractor relationships. However, the NGO community tends to see itself as an essentially or especially separate from the for-profit development companies. Even while they're funded by the same donors or implementing the same types of programs, even in the same areas. In fact, when looking at the professional associations which represent humanitarian development community, you will notice that most of them explicitly state that the membership is restricted or only open to these two types of groups independently. The for-profits have their own and the non-profits have their own. A 2008 study of the role of private security providers in humanitarian action showed that the main services they provided consisted of unarmed protection, training, and consultancy. The same study reported that although the provision of armed protection remains exceptional in the humanitarian NGO sector, all humanitarian actors, as in NGOs in this case, have used some form of private security providers for this purpose in at least one context. As unarmed guarding is the most frequently contracted service, most private security providers hired by humanitarian agencies are local, not international companies. The study also found that decisions to contract these local security providers are often taken in the field with little or no policy or practical guidance from the agency's headquarters. In humanitarian NGOs, internal capacity in safety and security management varies greatly. Some have nothing in place intentionally. Others make feeble attempts to try and get something in place at little or no cost to their organization. But there are some, and a growing number, who have exceptional security professionals and systems in place. Most U.S. and European humanitarian NGOs ascribe to the minimum operating standards for security, known as MOS, which Interaction, Security Advisory Group, developed in 2006. Recently, Interaction has required all of its members to self-certify that they meet these standards that are outlined in the MOS. Donors who are involved in humanitarian funding have not published formal standards, but over the past decade have taken steps to push their implementing partners towards better security management. For example, in August of this year, the Irish government, through Irish Aid, released guidelines for NGO professional safety and security management, which they say articulate the best practice standards expected from Irish Aid's partners in relation to security risk management, and have been designed to help NGO partners improve their own current security systems and fulfill their duty of care responsibilities towards their staff. USAID's Office of Foreign Disaster Assistance, also known as OFDA, has for many years required humanitarian NGOs to submit security plans with any and all proposals for funding. Over the past 2 years, they have started requiring the submission of a formal risk assessment, which informed that required security plan, which is an increase on not a standard per se, but certainly a requirement for funding. Development NGOs utilize various PSC services. Many, but not all, utilize armed PSC services either through direct subcontract for a specific program, or in some contexts rely on PSCs to provide life support type services in a group or commercial setting. While the use of PSC services at the project level is heavily dependent on the context of the implementing environment as well as the project's activities, most development NGOs will utilize certain other PSC services on a regional or global level. Many of these other services typically are in the areas of training, tracking, assessment, investigations, VIP travel support, or analysis. While development NGOs in some cases have more mature internal capacity in their security risk management, internal standards are often unevenly applied across the globe. Development companies utilize PSC services much like development NGOs. However, the deliberations involved in structuring the requirements do necessarily diverge with the tax status of the corporate entity. In terms of standards, development companies of substantial scale tend to adopt ISO standards such as ISO 9001 dealing with quality management. One area that development NGOs and for-profit development firms have in common is that their major clients or donors make no distinction between their tax status when it comes to the level of funding they require or request for their security programs. Development donors such as USAID require a security plan which covers specific components to be submitted with funding proposals in certain countries or for certain program activity types. Depending on the type of agreement, certain development implementers will also fall into a specific status which requires the staff implementing that particular program to adhere to the U.S. Embassy or mission's security directives and policies, which are issued by the ambassador or the regional security officer at the embassy there. The Australian government agency responsible for managing Australia's overseas aid program, commonly known as AusAid, but currently being merged with the Department of Foreign Affairs and Trade, requires both NGOs and for-profit development companies who receive funds to utilize ISO 31000-2009, the risk management principles and guidelines, as their standard for security risk management. To my knowledge, the Australians are the only donor who specifically require anyone receiving funds from them at this level to use a specific ISO document as a standard. Although not all types of NGOs or development companies utilize PSCs in every operation, the value proposition for PSCs would be greatly increased by ensuring the standards for security providers are developed with the specific needs of these non-state actors in mind and implemented prudently with the ability to monitor and evaluate compliance. A well-trained supply of professional security providers who verifiably implement security risk management services through a framework that is well understood and acceptable to the humanitarian development communities is possible, and has the potential to provide significant value to diverse stakeholders within the category of non-state actors. A key to the success of this effectively trained security resource is the understanding of their role and the proper application of their services within the context of the perceived need for them. The International NGO Safety and Security Association is currently the only organization in the world which focuses on the issues of safety and security in the humanitarian and development operations, which does not make a distinction between the tax status of the corporate entity delivering these services. INSA is in the process of establishing the first security professional development program specifically for the wider humanitarian and development community. A key element of this program is the professional security certification process, which will test, evaluate, validate, and grant multiple levels of competency-based professional certifications to individual practitioners working in this sector. And with that, I'll wrap my side up and look forward to the Q&A.
Great. Thanks so much, Trevor. Our last presentation before we begin to do a guided discussion of the scenario with Chris Mayer will be Peter McCormish, who is Director of Corporate Security for Barrick Gold Corporation. So he's responsible for the strategic leadership, oversight, and training programs for all aspects of security operations and product security for Barrick's operations in the Australia Pacific, Africa, and the Middle East. Prior to coming to Barrick, Peter worked in law enforcement for 25 years and will give us a sense of one more kind of client that needs to be trained. So over to you, Peter.
Thank you very much. Can you hear me clearly?
Yes.
Okay, thank you. What I'd like to do is provide a little bit of context to the comments that I'm about to make. I noticed in the beginning presenters' comments, Chuck mentioned the term battleground. We typically don't operate in what we refer to as conflict environments, merely challenging environments like Africa, New Guinea and parts of the Middle East. So I think it's important that we establish that context. The other aspect is that in respect to our operations, this is probably gets a little bit further into the weeds as opposed to Timothy's comments in regards to the way the ICRC operates. So it's really about how the rubber hits the roads. And the third aspect I wanted to mention is in respect to commercial clients. So unlike the majority of state actors and INGOs who have very clear mandates, objectives that are well established over a period of time, every commercial client is going to be focused on a wide variety of different interests and certainly different approaches. And I think it's very important to recognise that. And on touching on the issue of profit versus non-profit, as a former colleague of mine used to fondly say about commercial enterprises, it's not about the money, it's about the money. So I think the drivers that commercial clients have are going to be fundamentally different, which in the context of this overall scenario places the commercial clients as outlying data points with different sets of objectives, rules and cultures. So bearing that in mind, I've addressed this in 3 specific steps in addressing the question of who should be trained. The first is planning, the second is defining, and the third is execution. So I think it's very important, given the wide variety of commercial clients that may be encountered, and I'm going to address it through the lens of a member of the extractive industries, specifically mining, and Barrick being a gold miner is a particular niche within extractives. But I'll deal with extractives generally and explain the types of issues that we've encountered and which may overlay into other commercial clients, and especially in the extractive industry. So I think in the planning phase, one of the first things that we'd be considering and needs to be established very clearly is what exactly are the ground rules. And it is possible that some of these commercial clients may have had no prior experience in conflict environments or battleground environments. So the ground rules really are about identifying, developing a framework for the stakeholder interaction. So specifically addressing which stakeholders are going to be central to these specific commercial clients. And amongst those stakeholders, the specific responsibilities and capabilities that they have. For example, talking about whether it's a PMSC or a multinational task force that they're going to be dealing with, what authorities they have to operate in that environment, what their specific rules of engagement are. The next piece is what are the communication protocols between the commercial entity and the other stakeholders concerned. What emergency protocols do they have in place? And one of the questions that we deal with in interacting in our challenging environments is we commonly engage, and this is also seen throughout the extractive industry, both public and private security to secure our operations. So what are the protocols in place with local government agencies in terms of dealing with emergencies? So typically the authority levels and the rules of engagement are vastly different between the different entities, and it's very, very important that the commercial client understands what they are and that it's well addressed right at the front end. So the other aspect to it is normal operational protocols. One of the mechanisms that we commonly use throughout the world is developing an MOU, a Memorandum of Understanding, which clearly sets out the interaction between the commercial enterprise and the, more particularly, the public security agency that's involved. And the other thing that needs to be established very clearly at the front end is what are the operational objectives. So a commercial client's objectives are going to be fundamentally different to, although they may well overlap significantly with the other stakeholders involved. Once they're established and communicated to everybody, then it's fairly clear. So for example, if you're setting up an extractive type operation, the supply chain issues, there's certainly be commonality whether it's a state actor or non-state actor or commercial enterprise, but there may be some specifics. For example, in the extractive industry, you'll be bringing in dangerous products, explosives, non-military explosives, and also, for example, in the gold industry, cyanide shipments will be brought into site. So there needs to be very clearly some sort of formal risk assessment. Most commercial enterprises have well-developed formal risk assessment frameworks, and they tend to drive the way we do business and what we do in that decision making. So that addresses the planning component. What exactly is it that you're dealing with? Then moving on to the training issue, we need to really define the training. So the data, the information that's obtained in the initial stage would be used to define who is to be trained. And I think it's very important to recognise that in most commercial organisations, they're, particularly the multinational ones, they're very decentralised. And one of the perennial issues we deal with is the issue of operationalising the intent of the organisation. So, you know, is Planet Corporate effectively communicating with Planet Operation? And I think that's achieved through effectively defining what training has to be provided. One of the interesting things I've encountered dealing with extractives companies around the world is the level of maturity in terms of the drivers that Richard referred to, things like you know, the Alien Torts Act, the Foreign Corrupt Practices Act, prevailing human rights legislation, and one of the drivers that's inherently central to what Barrick does, the voluntary principles on security and human rights. You know, what's the level of understanding at the corporate end of the commercial entity? How is that operationalised down at site level or operational level? So I think that's fairly important. And the training that's required or the information provision that's required is commonly needed both at corporate and operational ends, but it needs to be clearly packaged very differently. So what are the people to be trained in? What are the specific commercial client requirements? The PSC clearly needs to have information on that, on how they're going to provide the service to the commercial clients. The PSC may not have had any training in the UN requirements, such as the peacekeeping guidelines, the VPs and so forth. And we find that that's absolutely critical, and we're commonly the, if not the direct source of training, the source of funding for training delivered by NGOs to public security and private security on things like human rights and the voluntary principles. And the other important part, given the scenario we've got for both A and B through the Civil War, is ensuring that a full understanding is provided at both a corporate and operational level on the scenario. The one provided in this case deals with a long-term civil war, but the cultural, political and security aspects of operating in that environment, it's very important that they're defined at the front end. And then the other piece I touched on before in regards to defining is who will actually deliver the training. So one of the reasons that we use NGOs for training in the VPs of public security in various countries is the desire for independence and purity of the training that's delivered, rather than be put in the scenario where a company may be rightly or wrongly accused of delivering its own slant on the sorts of drivers that are applied, whether they're voluntary or whether they're driven by legislation. So defining the type of training, who it's delivered to, and how it's delivered is very, very important. The final phase I want to touch on is the execution of that. So given that it would be a commercial client driving parts of this, particularly in terms of what they want the PMSC delivering for them, is validating the training content. So that would be some sort of loop back into the overall control of the peacekeeping operation to ensure that it's consistent, validating the delivery plan. And one of the aspects of that is localization. One of the difficulties we've experienced is corporately we develop training packages, what has been considered as good systems, standards and procedures, merely translating them into the local official language may not be enough. For example, if you look at New Guinea, population of 5 million, it has 800 different languages. We've encountered scenarios dealing with local communities in conflict situations where nobody in that community spoke Pidgin English. So merely translating it into the other official language of PNG would not be adequate. So we've had to explore a range of options in various countries about how do we actually transfer the knowledge, how do we ensure that there's some comprehension of the training. So localization of training and delivering the intent of what it is you're trying to train people in to ensure alignment with the overall peacekeeping operation is absolutely critical in our view. And we only uncover that through our own internal governance audits and validation of our various training programs. So the whole aspect of validation of the training and knowledge transfer is absolutely critical. And it may be that that becomes a component of any form of accreditation. And of course, finally, there needs to be some sort of look back in terms of review of the training as well as the validation and then improvement and adjustment.
Great, thank you very much. So I think we have a sense now of the complexity of the situation that that we're talking about, and we are going to take about 10 minutes to do a Q&A before we go over to look at our scenario. And so if you have questions, it's going to be a little bit awkward. You need to raise your hand. The people at Headquarters Central, which might be in Rebecca's living room, are going to find you, and I can't actually see your hand being raised, but they will and call on you. And so while you're raising your hand, I actually have a question to start us off in sort of thinking about the interaction between these different clients and the private security companies. And I guess it's mostly to Richard Phillips. To what extent do you feel like, do private security companies also kind of have a role to inform, in some senses, their clients of the appropriate training they need in order to effectively oversee them? Because some of the issues that the private security company might face in being compliant, for instance, to standards or the ICOC requires a certain amount of undertaking by their clients. And so I just wondered, Richard, if you'd address the issue of to what extent you really need to educate your clients.
I'd be delighted to. Can you hear me okay?
Yes.
Super, thank you. You've actually hit quite a significant issue, actually, because it would be fair to say that clients vary enormously. We have clients in the oil and gas and the extractives industry who are very sophisticated and understand what their part in this process is very, very well, though that's not universal. As you move down to oilfield services providers and tertiary providers, that knowledge can disappear quite rapidly. And the same applies within the international NGO market and the development market. The larger USAID implementing partners are very well versed in their requirements, but some of the smaller organisations not so. And it is a real challenge because ultimately the relationship that we're going to have is going to be a commercial one. There is an ever-increasing commercial pressure to reduce costs. So being told that here's something else you need to think about and do and pay us to do is often quite unpopular. And as not all providers, and I think most Western providers would be security providers would be quite honest and open about this, and they're not going to avoid this subject. It would be fair to say that a lot of local firms will not pay any attention to this. So you might well end up with somewhat of a disparity in terms of the provision. Now, I'm bound to say something like that, but clearly I'm also pointing out, as my father would say, the bleeding obvious. So it is an issue. It is one that we try to overcome through discussion whilst we're in the scoping phase. But again, sometimes that is hampered somewhat by arm's length procurement, where an RFP is issued and the ability to actually discuss matters is withdrawn. You're not allowed to contact someone for competition reasons. But that makes it more challenging. So it is an issue. It is something which we try to include in our proposals, so that we explain what is required, and we opportunities like this are extremely important to try and spread that word. But the trouble is that the people that we're typically spreading it to already know. So I'd be fascinated to see if other people had any thoughts on how we could do this rather better, because clearly it's something which we struggle with.
Great, thank you. I think we have one question from Glenn. Glenn, do you want to ask your question?
Can you unmute? Thanks. Thank you, Debbie. And I'm going to unmute Glenn. Mohammed, if you could help us do that really quickly. Bear with us for 1 second. She's up top right there. Okay. Yeah, Glenn, go ahead.
Can you hear me?
Yes, we can. Thank you.
Oh, hi, Rebecca. So my question was to Trevor Hughes. I was somewhat taken aback, and indeed to hear that most NGOs regarded security as something for field decision, and presumably on that basis they don't have the opportunity to do much due diligence into their security providers. Therefore the risk must be all the more considerable. I wondered if that was now beginning to change, and for instance, having heard Richard's magisterial presentation, if the NGO community were beginning to realize that the PSC world were now, like other companies, very conscious of risk, very conscious of human rights, and seeking to provide a very serious service to clients.
I think that, number one, a lot of my presentation was trying to break down in very general terms the vast diversity when we say NGO. It is really a fiercely independent group-by-group category. So absolutely, I would say that every level of what we would put in the humanitarian development community of organization has progressed over the last 12 years or so in the safety, security, risk management arena to some extent, but it's an extraordinarily varying extent. I'd say the development side of the house certainly recognizes this. I think that there are some in-the-weeds factors that if you really looked into certain insurance policies, certain crisis management, special risk type situations, that the vast majority of NGOs would automatically hold, whether they know it or not, within their global insurance portfolio, automatically have specific PSCs and related companies as preferred or contracted responders in an extraordinary environment. So while many might not recognize that, there are a lot of intersections here for both the recognition of the evolution of PSCs as well as actual kind of subcontracting those services. That said, especially in the humanitarian responder side of the house, it is a very different recognition level. And as I said before, I mean, statistically at this point, the vast majority of private security providers they use are local in whatever context they are in. And what disturbs me about that, obviously, is one, the finding that so much of this was done at the field level, and as our Edinburgh International presenter pointed out, there are certainly a wide gap in knowledge or priorities of these types of standards and recognition of rights generally in many of the areas we work where local providers would be utilized by these humanitarian NGOs.
Great. Oh, whoops,
Can I make...
Yeah, go ahead.
I think one of the, what seems to me, one of the urgent aspects is to ensure, when coming back to your core question, who needs to be trained, the message of who needs to be trained on what among international PSCs I think is pretty well established. As Richard said, most of them already know. Where I think there is huge ignorance of where standards and requirements are going is precisely at the local level of local PSCs, who may just be former law enforcement officers of varying quality. And I admit I don't know how you reach them, but I think that is one of the biggest issues, and that is where most of the kinds of scandals or abuses that are reported by, say, business and human rights tend to emerge.
Thank you, Gwen. Rebecca, do we have another hand up?
No, I think at this point there's no more hands up, and we've got about half an hour left. So, Debbie, if you want to give Chris Mayer a brief introduction, let's hand it over to him. I'd say. Thank you.
Yes. So, for the last 30 minutes, we'll have a guided discussion through our scenario in Alta Sierra, and Chris Mayer is a great person to guide us. He is the Director of Contractor Standards and Compliance in the Office of the Deputy Assistant of the Secretary of State of Defense. I'm sorry, Chris. Will you forgive me for that ever? And he has worked endlessly on issues having to do with contractors, private security companies, and how to best ensure that they comply with human rights and international humanitarian law. So, Chris, I'll turn it over to you.
There. Okay, I am unmuted. Can everybody hear me?
Yeah, we can,
Chris.
Chris.
All right. Wow. I'll tell you what. I thought that I had a good grip on who needed to be trained, and I probably thought, you know, I'm wondering why we even did do this. We can just come up with a list among 4 or 5 smart people and have done with it. And I have had a learning experience today, so that's it's really good. But we're going to, as you might remember from what I mentioned last week, the breadth of the things that you could possibly train people on and who needs to be trained is almost an impossible animal to get our hands around entirely. So the goal was to go back and just focus on those things, on the words in the mantra document itself, on those elements that are suitable for standardization and training. Not things that require a boutique approach or a specific training for a specific training environment, but what things can we say are generally applicable across the board, and for our purposes here today, who needs to be trained. I do want to address one thing really quick before we went on. Somebody sent in a question about a distinction between private military companies and private security companies. And we did address this a little bit last week. We understand that the term private military and security companies is in common use and is especially loved by people like Tim French at the Red Cross. But we believe that it's not a useful term in many cases, that there really is a strict division between private security companies and private military companies. This series of webinars wants to address both of those types of functions or services that are being offered. And as we go through the scenarios, you will see that we are addressing both elements of this. But it's also useful in our mind to think of the fact that private security companies are not inherently military, that they're working for, as Tucker brought up, non-state enterprises and performing services that are not, in fact, uniquely military. Whereas, on the other hand, there are also such companies that are providing what can be called uniquely military services. And just to name one on each side of what that could be, we have MPRI that acts as military trainers for senior officers, and in fact will frequently act as staff augmentation and support for developing militaries, and KBR, which provides logistics support, which are you can say, well, these were what the Teamsters and so on traditionally provided to military since the 30 Years' War. But we began to think about the fact that they're provided by, we came to believe because of World War II that they're typically provided by military forces. But anyway, you have both of those, and we need to address all of them as we're trying to implement terms of the Montreal document, which of course does apply to both private military companies and private security companies. Okay, now with all of the wonderful things that we just heard, we need to go back to the question of who should be trained. Now this is the scenario was brought up in front of you that we talked about last time. I'm not going to go over to it too much in depth, but we're going to say that within the context of the scenario, okay, this gets us away from some of the difficulties that Philip brought up, and we need to we don't need to think about the whole world. Let's think about just this one scenario where I try to capture most of the world. And the services that are going to be performed, and then who in the entire theater needs to have some sort of training addressed to them. So I'm going to read it to you again, even though I know that you got it all and you don't really care about me reading it to you, but I will. Okay, consistent with the authorization of the transitional government, requests for proposals are being prepared for private military companies and private security company services. These will come from various states to providing support to the reconstruction of Alta Sierra, along with various NGOs operating under UNDP or in support of the development agencies of supporting governments and commercial extractive companies. The government of Alta Sierra may prepare its own RFPs using request for proposals, using funds provided by other governments. The following services may be required: guarding of residential compounds of expatriate aid workers, site protection of reconstruction and development projects, including oil and extractive sites, convoy security for humanitarian aid and reconstruction supplies, personal protective details, police and military training, humanitarian demining, security of civilian merchant vessels carrying commercial and humanitarian cargo. So within this, we need to talk about who needs to be trained on issues regarding the use of PSCs. Now, though I'm looking at all of the presenters and the other people who have signed in, and I see that we have a very broad spectrum. And if you could just come up with ideas, raise your hand, talk about them, we'll put you online, and we'll mark them down as to who needs to be trained within your particular sphere of expertise, whether that is as a extractive sector client, as an NGO client, as PSC itself, as a government entity, and so on. Let's talk about it. So who would like to begin? It'll be a really
Okay, Chris, I'm looking here to see who's raising their hand potentially. I don't see any hands raised quite yet. Let's give folks here a second. Again, just remember to click on that sign that looks like a little hand with the arrow pointing upwards and allow you to pose a question.
While people are thinking about it, I'll start because somebody brought up that there aren't any people on the panel from the military. I'll fill in for that. And I will say that there are certain things that absolutely need to be taught to military officers and planners. And So I'll put in there military officers, planners, and soldiers in the field as the first one. Category who needs to be trained.
Okay, thanks, Chris. Do any of our presenters or Debbie as moderator, do any of you want to comment on Chris's question?
Well, this is Debbie. I think one of the interesting things to reflect on is the degree of people in Alta Sierra, people working in the local NGO community, or perhaps local companies, perhaps even local companies that have just been formed because they see there's a potential market. That seems to be one important set of actors to train.
Debbie, so I'm writing that down, and it's so people working in the NGO community and people who may see a market or be able to who want to be part of the market.
Right.
Okay.
This is Chuck Tucker. One of the points I'm making is that I started out by talking about NGOs, INGOs as private sector entities hiring or subcontracting to a PSC. But what I'm increasingly seeing in the field is that INGOs are directly hiring individual contractors and putting them on personal services contracts. And so what you have is you have the NGO itself, or the INGO itself, which is providing its own security, and it in effect becomes its own PSC. So that gets you into a whole different level of compliance issues, national and international, as Sorcha McLeod and Nigel White have pointed out. The law is morphing. The IOs are increasingly being held liable under international law, and I think that the trend is going to go to these kinds of international NGOs and them be held liable under international criminal law as well as civil law. And they need to be trained.
Okay, I would bring out that if you had an NGO that was working under a U.S. government contract in a conflict zone, and they hired their own private security providers, and remember that the ICOC is the International Code of Conduct for Private Security Providers, not necessarily private security companies, then they would have to follow all of the regulations for a PSC under U.S. law. So just something to think about.
This is Trevor. One of the distinct clarifications for that scenario there is I have yet to see a development NGO or a humanitarian NGO hire or allow the carrying of weapons for their internal risk managers or security managers. The majority of those two groups are hiring security risk management professionals who run internal security capacity of their organization and oversee their policies and everything else, and in many cases will be the experts that are overseeing the subcontracted armed security or PSC services if there are any. On the for-profit development side of the house, it's a mixed bag. I've actually seen some whose general counsels have allowed them to arm themselves under the idea of self-protection if it's legal in the country and they have like a concealed handguns equivalent license as an individual. But for the most part, any other for-profit development firm who may have a DoD contract or a defense contract on a military base under a certain USAID contract or a DoD contract, then of course they can be authorized by that agency to carry a weapon. Again, though, I've never encountered a nonprofit development or humanitarian agency international who are doing this or allowing their staff to ever carry weapons or perform armed security.
All right, but okay, so Trevor, you have not seen anyone do it. Chuck has. Of course, you're working in different areas of the world too. So, about who actually needs to be trained?
Let's go beyond those strictly carrying weapons, and I have seen INGOs who have direct hires who are carrying weapons. I won't admit to it myself, but theoretically we've done that ourselves. But there are other concerns. I mean, the trucking contract that was in a commercial realm in Afghanistan where direct payments were being made for protection to the local Taliban should raise eyes for all of us. And we have drivers that in some cases are carrying weapons, in some cases aren't. In all cases, they're engaged in some sort of security training. We may have hired them directly. If they're making payoffs to local police, militias, or the Taliban, that's another level of concern. So on the issue of not only who needs to be trained, but what needs to be trained, everything from the Foreign Corrupt Practices Act in the U.S., counterterrorism constraints and so forth have to be looked at.
Okay, and I think that to bridge the gap between you, and there's really not much of a gap, if an INGO is going to not only hire people for its own staff, or even but subcontract for its own security, and every major international human rights NGO has done it at one point or another, then the staff needs, I would say, needs some sort of training as to whoever's making these decisions to hire to know what they should and shouldn't do, what a PSC can and can't do, as brought up before. So I think Chuck's statement before that the INGOs need training as well, whether they're providing it for their own staff or whether it's because for oversight and contract management of security companies they hire. They definitely need to be on the list.
I just want to jump in here a little bit because it seems that some of the training requirements really depend on who is paying for what and who's a client for what. So if we're talking about an INGO that has some sort of contract relationship with the United States, it has a variety of legal requirements that are quite different from, say, a local NGO that is perhaps working, say, getting funding from local sources, getting funding from private sources, getting funding maybe from the UN. But it seems like, virtually all of the NGO and private security operators in this setting would need to be trained in issues having to do with the International Code of Conduct. And then there might be sort of additional layers having to do with U.S. law or laws in other countries that would be relevant, as depending on where the money is coming from.
Yeah, and Debbie, this brings up a point about these webinars. We had to sequence them somehow, and there was a great deal of debate as to whether we should start with who needs to be trained or what needs to be trained. And it's really hard to separate out the two. And we understand, and so we're facing a difficulty. Sometimes it's very hard to describe who without also describing what. That's not bad, because just remember the what for next week as we come in. You've already started thinking about the what's, and ultimately we'd like to come up with some sort of matrix like like we previously showed, but maybe more intelligible for all of us.
I mean, Chris, let me just jump in there because I can see what you're hoping to do, which is to simplify this to a point where we can actually wrap our arms around it and understand it. Sadly, the real world conspires to defeat that objective or that desire, because, as you said, there is a massive causal link between what is trained to whom. You really can't extract one from the other, and it is fantastically complex. And to a very large extent, I'm looking down here, so looking at technical training, legal liability, social responsibility, operational employment. Well, from my perspective, from all of my program and project staff in country, pretty much all of those apply to everybody. You just have to be a little bit thoughtful about how you train the local national staff, because I mean clearly it has to be in an intelligible format. And if you sit down and give a 70, I have actually seen this start, not in my own company, I'm delighted to say, a 70-slide PowerPoint on Foreign Corrupt Practices Act to a group of 30 Afghans, and they look at you in a very, very odd fashion. So the answer to the question of who needs to be trained is pretty much everyone. Actually, the answer within the private security providers, the question actually then becomes, what do you train them in terms of what is actually applicable. And Foreign Corrupt Practices Act, as far as a local national is concerned, can simply be, we do not bribe, we do not accept corrupt practices. These are what they are, do not do them. And it's not a discussion, it's an instruction, because that's the way it has to come across. And then in terms of in answer to the question, who needs to be trained, I would suggest, I've just looked at our training tracking system to see who in country gets what training, and the answer is they get a lot of it. They're probably about 70% of the operational stuff is pretty much the same no matter what the country or no matter what the client. But deep and a meaningful understanding of federal acquisition regulations might only be applicable if you're working on a USAID contract. However, actually a lot of what's said in that will be duplicated in International Code of Conduct or elsewhere anyway. So frankly, there's so much overlap. We literally can't distinguish.
Okay, Richard. I think that the point is well made, that it will not serve us really well by diving into who within a PSC needs to be trained, because the answer is all of them, right? But then we'll get into what, and as you said, and even questions like weapons training. John McGarry from Diplomatic Security at the State Department brought up weapons training, and weapons training is probably not exclusive just to the people who are providing the protection, but there may be some sort of weapons training that is also suitable for the people being protected. But these are things that we'll move on to later. So let's move outside of that.
Chris, it's Rebecca. If I could jump in real quick.
Yeah.
Chuck Tucker, Chuck, if you want to meet yourself, you made a comment of adding board of directors set list. Maybe you just want to expound for a minute or two as to why boards of directors need training as well. And then Lisa, you had written a longer comment. We'd like, if you'd like, you could ask us a question. So just text message us if you'd like to be unmuted to actually ask the comment or make the comment. Excuse me.
Yeah, the issue for me is effective control. From an international law perspective, IHL perspective, traditionally we've looked at who is in control, what level of authority do they have, and so these come down to command and control issues. As I look at corporate liability cases, particularly in the Foreign or Alien Tort Claims Act cases, a similar analysis has been used when we get away from the strictly jurisdictional issue. So what I'm seeing in the field is that the field is acting one way. The boards of directors and the headquarters may not quite know what's going on there, and yet when the lawsuits come, and I'm predicting that they will increasingly, the boards of directors are either going to be held liable because they exercised command and control or authority, effective control, or because there was a reckless disregard. And I would also say that some of our funders, when we take money from private funders in particular, they come with more strings attached oftentimes than come with, let's say, a USAID contract. In other words, the funder comes up with the idea and asks us to implement. The funders need to be trained on some of the requirements and what their responsibilities are going to be, since they're controlling the money, as would certain underwriters. Some industries, the underwriters are far more advanced. I'm thinking of maritime. But I have to say that my own insurance companies have very little idea of what the potential liability is when we have people in the field doing certain security operations. And so I think that increasingly the insurance companies who have the ability to turn us on or off are going to have to receive some level of training.
One quick point. We have 10 minutes left, and I know that Rebecca's going to want to try to do some wrap-up.
Yeah, and actually, Chris, sorry, there's also 3 more questions. I want to make sure we get them. Maybe we can take them collectively.
This discussion doesn't end at the end of this webinar. Continue, send the information out, send it to the general distribution that Rebecca's already provided for you. We will capture all comments and we will review them at the beginning of the next webinar. Okay.
Yeah. So Chris, I'm going to unmute 3 people. Lisa Shirk, and please then jump on in this order. Lisa Shirk, Katery Carmola, and Mike Edgerton, I believe it was. Yeah, okay, so you guys are unmuted, so if you guys want to chime in, feel free.
Okay, this is Lisa. I just wanted to make sure people understood that there has been a broad effort in the NGO community to do security training courses and to have security protocols in place. the NGO community has put a lot of effort into training their staff in security protocols. I also think it's important to further explain that the primary NGO security strategy is the acceptance strategy, where NGOs negotiate with armed groups and local populations for permission to do their work. And that has been shown to work. It's worked very well, actually, in parts of Afghanistan, where NGO workers may be kidnapped and held, but they are eventually let go once the research is done on their stance and their independence from the military. So I think it's really important that NGOs, you know, actually keep their distance from private security companies, because the closer that perception is locally, the less trust they have with local populations, and the more they will need to use protection and deterrent strategies in the future. I wondered if any of the panelists wanted to comment on that.
Hello.
Hi, Lisa. This is Debbie. I agree with your thoughts. I mean, one of the issues that's, I think, important in the NGO community is, even if they're keeping their distance from private security companies, which some do better than others, it's important to understand the requirements that private security operators,
Yes.
you know, they're sort of the overarching framework. So I think the training piece is still important, particularly because in the development of NGO standards, as well as the standards in the commercial client category, you know, it's best for everyone if there's some sort of commonalities or common understandings, so that they're not working at cross purposes. And actually, you know, no one in the NGO community is interested in developing standards that, you know, don't enhance human rights or international humanitarian law, but, you know, making sure that they don't sort of inadvertently undermine something that the code of conduct or something is trying to do.
Yeah, that makes sense.
Okay.
Hi, this is Catering. Sorry, I'll just make a quick comment. I put my virtual hand up before Richard spoke a little while ago, so it sort of seconds what he was saying. But I think, isn't the big message that everyone deserves to hear as much as they can about this world, but the baseline message is that this is not an unregulated space or an unregulated world. And so even if you just give that message out, there are rules, there are standards, there are best practices, and we can, you know, that's the baseline that all the different groups need to hear. And then you can just graduate it and have, you know, more complicated lessons, the 70-point PowerPoint, not for the Afghans, but, you know, somebody in-house, your compliance person. So it's not a question, just a comment.
Thanks, Catering. Thanks for that. Mike Edgerton and then Jeff Gruber, and then I think we're going to have to wrap up. Chris, I'll let you close with any comments before I make a few closing remarks myself.
Yeah. Hi, this is Mike Edgerton. Hope you can hear me. I'm calling from Beirut, and the signal doesn't seem to be too good. The one thing I noticed, just going back to the scenario and training, is what I think is useful to consider also is training. When we talk about training the who, and certainly this scenario is applicable, is the issue of training the local government regardless of its level of capacity. Even in this particular situation, I'm reading a little bit of South Sudan in here, it looks like, if I were to take a guess. There's the issue of, even if the government's not fully capable of executing its full responsibilities, there should be a capacity building piece that includes training for the oversight of the PSCs within this context. There's just something I throw in there rather than really just looking at all the kind of tactical players, but look at it from a more strategic or programmatic level as well.
Okay, thank you. Thanks for the comment. Jeff, do you want to make a comment or ask a question?
I think it's more of an observation than it is a question. And again, it just goes back as we continue to talk about training and standards, and where a lot of these things are being looked at in hiring of local nationals. And we've seen already that in a lot of the countries that we're dealing with, that one of the biggest challenges is simply the reading and writing, and not even in English, but of the local language. And I'm just curious as to what considerations or actions are being looked at to potentially address that, especially from a liability standpoint, as you look at these standards and actually try and have persons and companies adhere to them.
I mean, this is Richard. I can add some. I can give an answer to that if you wish, in terms of how we deal with this, and it is clearly an issue. We have in place a training system which is web-based. Clearly, that stops immediately when we get to local nationals who not only can't use computers but can't read or write. So the lesson at that stage goes into the hands of the allocated manager / trainer, if there is a dedicated function like that. The lesson is conducted, the lesson is downloaded, is conducted, and then the attendees undertake an assessment which is captured, and that is recorded back into our system so that we can look at who has received what training, and we do so biometrically. We capture fingerprints so that we can say, so-and-so received such training on such and such a date. And this might be, there might be as many as 70 lessons that a local National Guard undertakes in a country. And so that's how we currently deal with it.
Yeah, it's Peter here. If I could add some comments to that. Literacy levels also have a significant part to play in this. And there's parts of Africa where we have both PSC guards who are national and employees. And where we've got to, at the extreme end of that, is we've produced scenario-based training which is in cartoon format, both in PowerPoints, printed documents, and also role-play scenarios to actually train people in concepts and to enable them to have some understanding of what are essentially abstract Western concepts on security and human rights. So we've taken it right to that limit to try and ensure that knowledge transfer. It's a very difficult question, complex and often unique to that particular environment.
Both great answers. I really appreciate that. And also to your point, Richard, I find it interesting on the biometrics data, and would just ask if you've had any issues with that, because many times, and especially we've seen in recent years and after recent actions, local nationals are very, very hesitant. Local leaders that are potentially in that community are very hesitant to let their persons give up their biometrics data. Have you had issues with that?
We haven't, no. I basically, in Iraq and Afghanistan, which are the two countries where this is most, the biggest issue for us, well, not issue, is where this happens. The Ministry of Interior and/or the US military or NATO, ISAF, require biometric testing anyway for people to go onto these jobs. And this sort of, I'm going to swerve slightly back to a comment that was made earlier on. I mean, we actually work on an acceptance model as well as private security companies. We try very desperately not to use weapons. We rather like to operate in an environment by consensus, and part of that is actually engaging with the local communities, the local leaders of all different types, and we have to be very cautious not to have favourites, as it were. And then actually we sort of we explain to people what we're going to do, why we're going to do it, how we're going to do it, what the benefits of undertaking all of these requirements, and we give out a lot of training. So ultimately we're employing and training and taking on what we consider to be a very important mutual relationship with the local community and the people within it. So I mean, it's certainly not been an issue for us, but I think a lot of that comes down to approach.
Thank you, Richard.
We're out of time now, and I do want to assure you that I've put down all of the things that all of the people, all of the who's that have been brought up here. Please continue to send them in, and we will continue to collate them, and we will put them together along with some of the things that were brought up in terms of what's that needed to be trained. And we'll try to start matching those, and next week we'll have a discussion about how to apply the what's to the who's.
Thank you, Chris. And I also want to just second what Chris said. All of you who are on today's webinar will be added to our email burst so that we can move the conversation forward. As I said in the past, naturally, should you choose not to be part of that email burst, just send me an email directly and I'll remove you. But I want to note there were a couple more comments that we didn't even have a chance to take or discuss. So please do share with the group. Let's move the conversation forward in between webinars. It sounds perhaps counterintuitive, but 2 hours is not much time to discuss this issue, as you see. Our presenters really did a great job of laying out the complexity of these matters, and so please move the conversation forward. And I just wanted to also remind you to go to the website to register for the next webinar. You must register for each webinar individually. And I wanted to, again, thank our presenters, thank Chris, thank our intern Mohammed Abusheib for running the webinar, and thank all of you for actively participating today. Let your colleagues know about the workshop if you think they might be interested. Take care, and we'll speak to all of you next week. Bye-bye.